Madam Chair.
Welcome, folks. This is House Corrections and Institutions Committee. It's Thursday, April 24th, and this is our 9 o'clock meeting. We're back working a little bit on H 379, which is our legislation for second look in terms of sentencing. We've heard from DOC, we've heard from the judge, Zone, and we heard from the Defender General, Matt Valerio. So today we have with us the legislative attorney from the Vermont Department of State's Attorneys and Sheriffs to weigh in on 379. So Kim, welcome.
Thank you so much, Chair.
If you could identify yourself for the record.
Absolutely. My name is Kim McManus with the Department of State's Attorneys and Sheriffs. It's the first time I've been in the room with you all. I know my department was here a few weeks ago on victim notification. So I am the new Tim.
New Tim. But Tim is still around.
Tim is still around. So he's very nicely been easing me into his role. So I'm happy to be here with you all in person. Listening to the testimony yesterday, I think you all heard very clearly from the judiciary and the Defender General that the bill as written has a lot of issues. I'm not going to reiterate those issues. I don't think that would be helpful at this time, because what I heard yesterday was a possibility of looking at ideas that have been brought up in the past that might be a bit more viable. So I'm not going to run through all of our issues in 379. Our department as a whole, generally speaking, this is not every single person, but last time we surveyed our department, I think the number that was given to me by the executive director was around somewhere 175 out of 178 opposed second look legislation in general. We have a really tough time with lacking finality in sentencing. It is very, very difficult to say to a victim, currently, even just talking about earned time is incredibly difficult. Oh, here's the sentence that we think we have. Oh, wait, the sentence may change. We're not sure how it'll change. Maybe it'll change a little bit this way, maybe a little bit that way. That is already an incredible difficult conversation. To have a conversation with a victim or a victim's family that says, you know what, we should look at this plea agreement. We'll know what we're getting at the end of this agreement, but then say, well, we'll know what we're getting, but possibly in 15 years, if it's a case that falls into that range, this could all change. Very, very hard to do that. And I really appreciated Dr. Reese's testimony that not all victims are the same. But I would say in general, in conversations that I have personally had as a prosecutor and working with our victim advocates, the idea that the sand is always shifting for our victims is traumatizing. Every time that a post-conviction type hearing happens, whether it's a PCR or a habeas, and you heard a little bit of that yesterday, we notify our victims. We need to notify them of the hearing. We need to get their opinion. This is 5 years, 10 years, 12 years out from the disposition of the case. And what we hear from our victims is they then have to relive the event, right? They're always waiting. Is there another phone call? Is there another hearing that I need to go to? So that's big picture, our main concern with second look legislation. If you all would like to have the judiciary, the Defender General, and our department have a conversation about what was considered in 2020, about the idea that there could be an agreement if the prosecutor up front was on board with that, that's a conversation that we are happy to be part of. I cannot today, on behalf of the department, say that we support it as a department. I would need to survey our field. We have our training in June, and I'd be able to do that then. So if you did want to create, I know working group is sometimes a word that we don't want to use, but if you did want to create a group or would like us to work on that before next session, we would be very engaged in that. But as of today, I could not say that we support the idea that was raised in 2020.
But you'd be willing to engage in conversations with the Judiciary Defense Counsel and State's Attorney. And for the committee, just to give you an update on what she's talking about, because this was presented to us. This was presented to us by both Judge Zone as well as the Defender General, but back in 2020 through the Sentencing Commission, there was a proposal for sentence reconsideration. And right now, by the rules of criminal procedure, which is how the judiciary operates, and I'm assuming it's also in statute. Right now, the court, on its own initiative, on a motion from the defendant, may reduce the sentence within 90 days after the sentence is imposed. So there is a window of 90 days after a sentence has been imposed where they can reconsider the sentence. So that's current. And what the discussion in the Sentencing Commission, and they came up with a proposal that goes beyond the 90 days. So it reads a stipulation to reduce or modify a sentence. Any court that has imposed or is imposing a sentence under the authority of this title, so there's a sentence, upon the stipulation of the prosecutor's office that prosecuted the case and the defendant, reduce or otherwise modify the sentence at any time after the imposition of the sentence. So instead of a second look, where the person would have to be incarcerated 15 years, and then it would be up to review, what this would say is that it's up to the prosecutor of the case can look at, and the defendant, the court could look at reducing or modifying that sentence at any time. So that's what was recommended by the Sentencing Commission back in 2020. And there was an affirmative vote of the members. There were 3 state's attorneys that voted no on it, and there were a couple members that were absent. But the majority of the Sentencing Committee recommended this change in 2020, but it did not get through the legislature. So that's what Kim is referring to, is having a group of folks look at this proposal that was out there in 2020 instead of 379 second law. Sorry.
Yeah, do those 3 no votes indicate a position from the state's attorneys in 2020? Do you know that? I know you can't speak on it where you would be right now, but do you know where you were in 2020?
My understanding, and I was not, I just started with the SA's office in 2020 and definitely had no idea of this world. I was barely holding my caseload together. I believe our executive committee, so we have an executive committee of state's attorneys. It's 5 state's attorneys elected by the other 14 state's attorneys, have been opposed consistently to this. Now, I would have to go back, and I can give that information to the committee to find out the breakdown between who was on the, not who, but the representation on the Sentencing Commission versus our office.
Thank you.
And 5 years later, I don't know what the temperature would be, but that's what we would need to check.
Can I ask another kind of along that? How do you see, just in a general sense, the state's attorney's position on this sort of question, second look, whatever we want to call it? How is the state's attorney's position evolving as we move more towards a restorative model of adjudication? And I can appreciate those conversations are incredibly difficult to have with the victims in the moment of, 15 years, but that might change, right? Are we moving? I have a pretty good handle on kind of how restorative practices are being viewed through the community justice centers, just kind of through a general approach across the state. I don't have a good sense of, is the state's attorney's office on board with that shift in approaching the judicial process?
I think the fair answer is that that would vary across the 14 counties.
Yeah.
That you would not have one answer. What I do consistently hear and what I remember experiencing as a prosecutor is that if the restorative justice model needs to be robust, so that when you go to have these conversations with victims about, jail time, or
Yeah.
what else, there has to be a what else that feels like
Right,
it
certainly,
provides,
yeah.
right, something to them. And there often isn't that yet. And especially when we're talking about the most serious of offenses, right? And I think there are victims who are open to a more restorative model, but we don't have a lot to say, like, okay, instead of 10 to 15 years, it'll be 5 years, but then all of this
Yeah.
programming will happen, and then there'll be this other event that brings some sort of closure. Like, we don't have that.
Yeah.
And so if we don't have that to offer, I think that's very difficult. So when, right, culturally at the moment, what victims expect is, not all, but again, thinking of our most serious
Mhm.
offenses that carry these longer sentences that we're more concerned about right now in this conversation. Even though I think there's a part of them that knows jail time isn't going to equal, me healing, and we have that conversation, it consistently feels like what happened to them doesn't matter.
Right.
When sort of lighter sentences are imposed for these incredibly damaging life events. I think the one other thing to think about is, there was information shared about aging out, that
Yeah.
criminal activity lowers as someone ages. And that is true generally, but not for all offenses. And that's something that I think if this moved down the road, we'd want to look into a bit more. I was an intimate partner violence prosecutor. I have a lot of information that I won't get into today, but in the area of sexual predators, that is not an aging out crime. That is something that is very hard to rehabilitate. And there's plenty of studies I can send your way. So I do think, being more individualized about the approach. And I think our state's attorneys and deputy state's attorneys do that regularly. They really look at the individual case and the situation. But I think for more to get on board with the restorative model, there needs to be more restorative options that really feel like they have some weight and heft to them and provide something to not only the victim, but the community, right? Because the victim's harmed in these serious cases, but your community is incredibly harmed when these events happen.
Thank you so much.
Do you, if there was the option or premise or whatever that the victim would have to agree on the second look, I'm in a position that I can forgive and believe that the person's restored, I'm on board. I would think that that would satisfy the hard line that I'm hearing from your side of the fence, if I may use those terms. And that would at least give an option for some to have been rehabilitated and given the opportunity for a different life and everything can come together. Now, what I'm hearing is, well, that'll never get passed. And I'm saying, well, I have a feeling you've got two hard camps and you won't get anything if the two hard camps never negotiate. And so that might be one way to bridge the gap, is to say, it looks appropriate and the victim says that they're comfortable with it, therefore it can move forward. Do you think that would make the difference in?
I think it's a integral part that the victims or the victim's family, his voice would need to be part of this decision, absolutely. Our victim advocates would absolutely insist upon that. I don't know if that would be the deciding factor. I do think there'd be a few, and again, not to tie us to agreeing to anything today, but I think the victim piece would be essential. I think this piece about it being a agreement beforehand, not a motion that creates a hearing, that creates potentially a lot of litigation. We already have so much post-conviction litigation. There are so many avenues for a defendant to ask to reconsider their conviction, their sentence. Adding another layer to that and just extending that, that part is truly exhausting, not just for the victim, but for our department. So that would be another piece. There's a resource piece that's very valid. So something that, yeah, the agreement beforehand versus it kind of being thrown onto us, like, hey, what do you think? And there's a hearing scheduled. That would at least be a starting point for the conversation.
Connor and then Frank.
Oh, sure. Actually, it was the most basic question that I probably should have asked 3 years ago when I came on this committee, right? You know, when we talk victims, and especially like in the case of like a really a heinous crime, like a murder or something, I wonder how do we define victim? Because there's like almost community trauma around that. If my sister-in-law is murdered, am I a victim? Do I have to like register with a victim advocate? Because in all this terminology, we're talking the victim, you know, like who is the victim? How broad is that, you know?
Well, that's a wonderful question. We speak often of the victim's family, as far as from our office, who we would be communicating with and connecting with resources would be the immediate family of the victim in the case of a homicide, or the person who has been directly harmed if they're still alive. I know I'm not going to get this right. There's legislation moving through, and I'll find it for you, but it was redefining. So not only physical harm, but factoring in that emotional, psychological harm for those who sort of are around it. For our office's purposes, we would not be able to advocate, you know, for all the individuals in the town impacted, but we do directly. But our state's attorneys very much factor in that, you know, there is the victim and their family's voice is critical, but we do constantly look at how did this impact the community? How does this impact public safety? Like that's always what the state's attorneys are weighing. when they're looking.
That's really helpful. Thanks.
But I'll find that legislation because it was interesting.
Oh,
They were looking not just physical harm, but emotional harm, enlarging that.
Kevin?
It's been a while. I love it. Thank you.
Well, at least you're not Tory.
Nice.
Yeah.
It's happened at home.
It's actually apropos because Connor had half of my question, but the other half goes to what Kevin was talking about in this notion of the victim's veto, if you want to call it that. I don't know, from your talking with victims, do they want that sort of power? That seems a lot to put on a person, and I could set you free or not, essentially. Maybe I don't want that on me,
It's an excellent point. That's an incredible point. And I think that is most certainly why we would not want, shall language attached to that. We would want their thoughts and feelings to be factored into the decision. I don't know if we'd want to put that entire burden on them. And again, we do have to be, when at the front side, when we're discussing with the victim potential plea sentences, we again want to hear them and have that factored in. Ultimately, it is the prosecutor's decision. We can't give victims do not get the ultimate yay or nay on pleas or whether we go to trial. And it's really balancing that, rational decision-making, emotional decision-making, like who's driving the bus.
Mm.
It still needs to be the state's attorney, the deputy state's attorney, but we very much need to factor in. But I think that's a wonderful point.
Okay, thanks.
Kevin?
I think, I hope it would go without saying. It's not, I'm not recommending that the victim have the yay or nay. It's that they would have the say that I'm not comfortable with the recommendation that there's the second look, and the recommendation is based on criteria that will hopefully rationalize why the victim could be comfortable with it.
Mhm.
It's just a sort of a safety valve where all the other boxes have been checked. They've gone through the remediation, there's remorse, there's, whatever the criteria is. I'm not smart enough to come up with that criteria, but then the victim has the other. And how do we define the victim? Oversimplified, which is always stupid for me to try to do that. But if they've said to Vine, I want to know what's going on, let me know what's going on, all of those people in my mind would be considered the victim. If they say, I don't want to know what's going on because I don't want to be reminded until the person gets out, now you've got a definition of who really would be considered the victim, maybe.
Hmm.
That's just a straw man, but I mean, your question's a great one, because it could be really broad.
Well, I wonder like if people in the immediate family disagree too, right? Like,
It
yeah.
could.
Yeah, it could be.
Yep.
Yeah.
Could. Well, that's a balancing act that the court has to do. It's a balancing act that the prosecution side has to do, and also the defense side. And quite often, and this is one thing I was going to ask, when you're building your case, and you have to build your case based on evidence, and the victim may think something is of evidence and it is not. That's where you're walking a delicate line, because you know what would stand up in court, and a victim may feel that would stand up in court because for whatever reason, and it doesn't. And that's where there can be some conflict, I would presume.
Absolutely. Yes. Absolutely.
So you're saying, in terms of, and I think, I'm not going to speak for the committee yet, because the committee hasn't made this decision. But there was discussion, and a proposal presented by Judge Zone, as well as the Defender General Matt Valeri, to really relook at the sentence reconsideration that was proposed back in 2020, and it wasn't acted on through the legislature, to revisit that. That was what was put forward to us, instead of doing the second look, that we look at that avenue. If we do that, what you're suggesting is that offer time for the three parties to really sit down and revisit that proposal. And then next session, you would have some recommendations.
Yes, that is what we would be comfortable with now. And I would want to flag that coupled with a few things that have been raised that might move our office towards a yes, is that we would, and this would be part of the conversation we would have with the judiciary and the Defender General, is if we were to create this system, other reconsideration, we would want to also look at some of the other post-conviction remedies, and in particular post-conviction relief, which currently right now is unlimited, and possibly request that there's a limitation on how long and how often that can happen. And there has been some limitation, but how far out that can keep coming back to fighting that sentence, we would be suggesting some balancing there.
Right.
So I do just want to flag that for the committee.
So that would be, there are other flags?
That one is
Conviction relief, because the testimony we received from the Defender General the other day is his office is just getting bombarded with that. And if we did some form of a reconsideration of the sentence, would really take some pressure off of that.
And I thought that was very interesting. We That would be a wonderful outcome. And if sentence reconsideration did that, I know that currently looking at the current bill, our concern is just, here's another one. And one thing for this committee to keep in mind, the Defender General's office has the Prisoners' Rights Office and their appellate division. Our department has one appellate attorney, Evan Mahan, and he's amazing, but he's one person. Otherwise, our state's attorneys and deputies do all of their post-conviction work. That caseload is theirs, so we don't have an office to send it to. So depending on how this settled or sifted out, we would potentially also be asking for resources, depending on which way we went, whether we thought we needed that. Maybe we wouldn't if the Defender General's prediction is correct. That would be incredible because, as he stated, it's very liberal what can be petitioned for post-conviction relief at the moment, and it is nonstop.
Troy?
Are you opposed to Dr. Reese from, or her designee from LWAP New England on that summer work group?
Am I opposed to the person being on? the
Yeah.
group? No. I mean, the only caution, no, I found her testimony very interesting. She's very knowledgeable. And I think this committee did notice the majority of our research was looking at national numbers,
Yep.
and we're a little light on our Vermont numbers. I would want this committee, and if she was able to help us dig into our Vermont numbers, then I find that very valuable. If it's coming from a national New England lens, I find that less
Yeah. Gotcha.
persuasive.
Thank you.
Sean?
I mean, I know we spoke about it, but how like robust is our restorative justice, like kind of, I guess, part of our, of Vermont? Is it really set up or is it just like really on lower level stuff? Because it seems like you can't build, you don't want to put the cart in front of the horse. You need that to be working really, really well for years before you even consider. It seems to me that that really has to be solid. You can't kind of stand these two things together. One has to be there for the other thing to be successful. So do we have a real, like, is that happening in our criminal justice system on a big level?
We have restorative justice programming. It is for lower level offenses primarily now in the communities, and it varies county to county what's available. But I wouldn't be able to speak deeply to all the programming, but to the larger point, as far as a robust restorative justice program for major felonies, I do not think so
Okay,
currently.
thank you.
It's a lot of history with the restorative justice. It's been around since the late 90s. And the impetus for starting it was coming from a commissioner of corrections at the time and seeing that corrections beds were being taken up by a lot of crimes that were low level in terms of severity of crime, medium to low level of severity of crime, and medium to low level of risk. And he was saying, we keep building beds and we're not going to be able to build our beds out of this. And we really need to look at a new direction. Why are we paying so much money per bed? At that time, it was like 30 or 40,000 per bed to house someone who has a low risk of reoffending or medium risk of reoffending and low to moderate severity of crime. We should be holding our beds for folks with a high risk to reoffend and a high severity of crime. And we need to repair the harm to the community. And that's where the restorative justice model really started from. And we started doing that in the late 90s. And it has grown since. And that's why now the beds that are being taken up in our facilities are folks with felony convictions, high severity of risk, high severity of crime, high level of risk. So here we are 25, 30 years later, And that's what's happened. So it is successful. And the goal was that for the perpetrator of the crime to go back to the community, go back to the victim. And the victim could be an individual person, or it could be that community or an organization within that community. And both ends come together and repair the harm. That was the model, and it's still there. So is it robust? Depends on the county. Depends on the county. And that's where you get into geographical justice all over again. It depends on the county. But we've done, and your restorative justice model depends on a lot of volunteers in a community to participate, to be willing to work with folks who have committed a crime and be willing to be open to understand why the person committed a crime, and vice versa for the person that committed the crime to realize the harm that they did to either a person or the community.
Yeah.
That's the model of the restorative model. Connor and then Kevin.
Yeah, they say not to ask a question you know the answer to, but I think we should keep bringing it up here just with the, I want to just ask what the staffing is like at the state's attorney's office now and how that might, make you hesitant to bring on anything that adds a workload to your plate. I was wondering if you could just maybe give us a briefing of how many positions you asked for, how many you got in appropriations, what you need, because I really believe this court backlog is costing us in so many ways. And I don't know if we're being proactive either with the defender generals or the state's attorneys by giving you both the resources you need to trim this down a bit. So I was hoping for, just an update on it.
I can give some general numbers. Tim Lueders-Dumont and Annie Noonan have been our budget. They've been championing our budget. So currently, our average prosecutor has 600 cases on average. That is unmanageable amount of cases, and that includes the post-conviction relief cases are folded into that number. It does vary by county. We have openings in, I believe we have 3 counties that are looking to fill positions. It's hard to find folks to come in to take on that sort of caseload. We had, and I'm going to get the number slightly wrong, so I'll have Tim send you our memo so you'll see the breakdown. But we had 7 limited positions for deputy state's attorneys. Those positions are filled, but we're asking for those to become permanent. That's one of our asks this year. And then I believe we were asking for 2 or 3 more deputies where we need, the deputies are integral to bringing that caseload down. What's even more integral is our admin staff and our victim advocates. That's where we, oh, and I apologize. I think I just got that number mixed up. Our victim advocates have 600 cases. I apologize. On average, our attorneys have about 300, 350. Sorry. I was like, wait a minute, that number was off. Still unmanageable, but really not what the victim advocates have. For our admin staff and victim advocates, we were asking for, and this is going to be rough numbers, but I think we were asking for 4 additional, 4 admin, 4 victim advocates, somewhere around there, 4 to 6. I do not think we're getting any of our positions that we've asked for, that I know of, or we're getting bits and pieces. But I'll ask Tim to send you the update because he has those numbers absolutely dialed in. But to the larger point, do we need more support? Yes. We need more prosecutors. We need more admin and more victim advocates. And on the, I don't believe we asked for it this year, but we would like to ask for a post-conviction relief attorney, somebody who just focuses on that work and could pull those cases off from the deputy state's attorneys.
Great, thanks.
Thank you.
Kevin?
It's, maybe I'm not supposed to make a statement at this point, but the reason I'm interested in it is because I was hearing that there's a possibility the PCRs could be greatly reduced if another off-ramp was introduced. I do believe that there can be, not always, rehabilitation and forgiveness. And so the balance of these activities would be better from a cost, an emotional, and a overload. That's why I'm interested in talking about this. But the criteria is the critical part, so that all the parties are satisfied that we've made the right decision, rather than just saying, here's a minimum sentence and it doesn't change, or you can just get out because of some unmeasurable experience. That's where I'm coming from, is reduce the cost, improve, those three things I think are a possibility if we approach it properly from the Vermont state, perspective, not the nationwide, but the Vermont perspective. And so, thanks for listening to me.
So I think this has been a really good conversation, and we'll talk as a committee. I did have a very brief, high-level heads-up conversation with Martin Lalonde about the second look bill. I said, I know the whole sentencing piece is not our jurisdiction in this committee. We are looking at it from the DOC end and knowing folks' length of time incarcerated and that piece. But we did hear testimony from the judge and defense counsel, and we will be hearing from the state's attorney. And I did mention with Judge Zone and Matt Valerio mentioned about revisiting the sentence reconsideration proposal. And Representative Martin Lalonde was on the Sentencing Commission at the time, and he does remember this. And I said, this may be something that we want to take a second look at. Take another look at. He says, okay, just let me know. So, I did have that high level conversation with him. So we'll talk as a committee and see where we are. We can make a recommendation to the chair of judiciary, say, this is what we're proposing and looking at. And it would be a group of folks, the three parties, possibly with Dr. Reese's input as well, and come back with a recommendation next session. So while you're in the hot seat, I have another question that has sort of come up from committee members. It's pertaining to detainees in corrections, folks who are being held for a variety of reasons. It's like 450 to 500 at any point in time. And in looking at that population, a lot of folks cycle through within a few days. They're arrested, then they go in for arraignment, and then the court releases them with conditions and for another court date. Those folks that are held in our correctional facilities, some of them are there for a year, 2 years, 3 years, 4 years. And the question came up, why are they being held so long? So I don't know if you could weigh in on that. We have our own thinking in terms of why, but now that we have a state's attorney in the hot seat,
So
might be able to shed some light on that.
just to be clear, so individuals who are being held before their trial, is that,
Yes,
you say detainee,
yes,
so pre-adjudication.
pre-adjudication. Come on in, Wanda.
So those
They're held
individuals
without bail.
are either held without bail.
With
or-
bail that they can make.
So then their cases, ideally, they're being heard in a timely manner. Those cases, if you're being held without bail, that is a life offense case, or a violent felony with a substantial likelihood that you'll be violent if you're released. So very serious cases, those felonies, those are all felony cases. They're complicated cases. So it's a combination of when to get the trial time, but also being prepared for that trial.
Building your evidence.
Yes,
Building the
so
case.
between the defense and the state, there's we fill out a scheduling order for those felonies. And often right at the start, that case is scheduled out, a year, just from all the motion practice that needs to happen, depositions that need to practice. There's a lot of work that goes into if this case is going to go to trial. And then within that, there are delays that occur. And so it can be 1, sometimes 2 years. And we're still dealing with we're working our way out of the COVID issue where we saw 3 years. I think where we've worked a lot, you've probably in the news seen, there's a lot of trials happening, a lot of cases moving forward. And those were individuals who were held for longer than a year.
And those depositions, you're talking to the victims, you're talking to witnesses, and that's both the state prosecution side as well as the defense counsel.
Yeah, the defendant has the right to depose witnesses for felonies, and then the state's attorneys can depose the defense's witnesses.
So both sides have to build their case. You have to work with the court schedule. And you're all, for the violent crimes, felony crimes, you're building a case to go to trial for a jury draw. And you get up to close to that point, possibly to actually doing a jury trial, a jury draw, and then all of a sudden it's like, can we make a plea deal? So you talk a little bit about how that, because about 95% of the cases, 97% of the cases are settled through a plea deal. They don't go to trial, but they get very close to it usually.
Yeah, so throughout the process of leading up to trial, each side is kind of poking and prodding at the other side's case, right? After each deposition, there might be something like, "Ooh, that witness is a really strong witness," and the defense attorney may realize that, and then the conversation may change as far as, could we negotiate something? So all throughout, there's sort of a balancing going back and forth. Sometimes there's no, that's going to trial, no one, whatever the offers are on both sides are so far apart that there's no likelihood that anything but a trial. But if it's more like we're trying to work our way towards the middle, as that process goes through, weaknesses are shown on one side or the other. If there's a suppression issue for evidence, that motion to suppress, that hearing occurs. If the evidence is suppressed, okay, that just changed the dynamic. Is there enough evidence? Is this now when we would please? So there's many stages along that pre-trial phase where either side might be motivated to come to an agreement. And it varies tremendously. But yes, right before trial, I wouldn't say it's a practice, but it's pretty much a norm. We always re-offer if there is a plea that we would find acceptable, that our victims are comfortable with right before trial. If you can avoid having to put somebody on the stand and have the uncertainty of a trial, you're going to offer it. Again, so sometimes it's day of jury draw or even day of opening statement, or even in the middle of the trial. Something could happen and a plea might be worked out. That's just the reality of our system. And the other piece, as far as time, everything will be ready to go. And then, someone's unavailable, someone's sick, something pivotal where then, okay, we need to move the trial out, another 3 months. That's where some delays occur. Especially when you're dealing with a big case of 20 witnesses, experts.
I think this is very helpful because that has come up when we're talking about the detainee population and how come there's so many and why is it taking so long? So while you were in the hot seat, I thought it was a good time to ask. So I hope that helped the committee in understanding some of this, and also for the committee to remember for folks who are detainees and then they do go to trial or a plea deal, and then they do have an ultimate sentence. For every day they have served, every day they have been incarcerated as a detainee gets counted towards that final sentence. So it's credit for time served. Just to keep that.
Out of the hot.
Yeah, you need to get out of the hot
Before-
seat. Thank you.
Thank you so much.
This morning's been very helpful. Troy?
With that, for one, and sometimes that is why people want to stay a detainee.
Yes. I didn't want to say that.
Not everybody who is a detainee is there because I'm making this argument.
Yeah, right.
Because they can't afford bail, or sometimes people are there because they can forecast that there's probably gonna be a conviction, and I might as well serve my time while I'm waiting for the court.
Right, there's some of that that does happen.
Do you have any idea what kind of percentage that would be? That
You went too many specifics. I'm gonna be like your wife.
That's why I asked, do we have? Hey, just relative, if it's 50-50 that's actually get convicted, or it's a 90-10.
Because I had that same question. when
I
she was
think it's
talking.
pretty high.
Yeah, I would hope that it's very high, but I just didn't.
I think it's pretty high. I mean, that would be a question.
Wouldn't know.
Probably DOC, DOC might know that because they would have to deal, I don't know.
But would they have an indication though of how many of them are likely to be convicted? How many of their detainees are likely to be convicted? Is that better for the court stand?
Yeah, I,
The state attorneys.
They're full court. Trial, and they actually are found innocent.
Yeah, we could do a word. We could
that's
easily
very
do a word.
few.
That would be the easiest one. but
Yeah, that would be very few. Good time.
I hope
Anyway.
it's very low.
So I know we've got a long conversation happening about Windsor and the Old Windsor Correctional Facility. Can we just take a quick 5-minute break for folks?
Absolutely.
Let's talk.
Yes, we will support.
Yeah.
Thank you.
Let's take a quick break.